Okay, once again, the state of Illinois is doing things they're not supposed to be doing and cannot do. A lot of people have a lot of concern about the quote unquote Homeschool Act, House Bill 2827, that's being put forward and it's gaining sponsors by the Illinois State Legislature. The long and the short answer is going to be contained within this video and on this notice. The short answer to this that most people are asking is, or that nobody's asking, is that can they even do this? And the shorter answer is no, they can't. The long answer is a little bit more complicated, but it's really easy once you get to the root of the issue. And we're going to try and cover that today. And with your participation with this notice, you can stand as one of the people and assert your rights and start enforcing the Illinois state constitution that everybody has let go by the wayside, including the people. We need to get back to a space where our representatives are accountable to the people, they're accountable to the Constitution, and our government actually follows what's supposed to be done. So the way that we're going to do this is by the people coming together and assembling and sending them notice. This notice is going to be automatically emailed for free to all of the Illinois state representatives and specifically addressed to the sponsors of the bill and the Speaker of the House. In addition to that, if anybody wants to participate at the very end of the process, you can participate by either mailing this yourself via certified mail, or if you want to participate in a group share effort just to cut down costs. If you participate in that, then we will be mailing hard copies of this to the 5 sponsors and the Speaker of the House as well, which will be in place of mailing each entire representative themselves. Before we get started on this, there's been one big problem with this that I see is not only from that there's an issue with the Homeschool Act, but there's an issue with how our representatives, even the ones who are against this, are responding to it. Because everybody is treating Illinois and America as if it's a democracy where the 50 plus 1% rule the day. And that is not true. That is not factual. And that is not law. That's not in our constitutions of each state and the United States. This is a republic, and it's important to understand that at a very foundational level, and you're going to see that as we explain this notice. One last thing before we get started, what a notice is, just like if you were, let's say you had your property and you had a fence you put up that is too tall for the requirements, which we won't get into the whole whether that's lawful for them to do or not. But what's the first thing that they would do? They would send you a notice to tell you that you're acting outside of the guidelines, outside of the bounds, outside of the limitations of the rules. What we've lost as the people is the fundamental principles of law to understand that's how we need to treat our public servants and our government. When they step outside of bounds, we need to notify them and let them know, that's not in our contract called the Constitution. In addition to that, it's much easier to do that before something becomes quote unquote law. That's why we're doing a remonstrance, and a remonstrance is a strong rebuke or an expostulation. It means we are basically shouting at them and telling them, no, 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 you can't do this. And we, the people, are sovereign. We, the people, are the ones that created this nation and this state. You are our elected servants. And so we are the masters, you are the servants, you obey us. So that's in essence what this entire thing is saying. So if you start here at the top, this is a remonstrance by notice, and we're going to notice to principal is notice to agent, and notice to agent is notice to principal. That means that anybody in government that touches this thing, they have been notified. So if they get the If they receive the mail for the representative, they've been notified. If they open an email or if they even receive an email, they've been notified. And it says, this first paragraph is very important. I, one of the people, as seen in the Illinois State Constitution, Article 1, Sections 5, 6, and 23, which is Republican in form, sui juris, do serve you this remonstrance by notice, so that you may provide immediate due care. That says a mouthful right there that we've lost in understanding as the people, because there are multiple state constitutions. The Illinois state constitution doesn't express it clearly for us. There are multiple state constitutions that express that government is formed and can only be altered and abolished by the will of the people. The people are the source of power. And that's what we're getting to in this whole thing. We're drilling this down to um, an issue right down to the core and to the roots. And the root of the issue here is that we have been taught or trained to think that we're electing leaders instead of electing servants. The people in Illinois are the kings, not government. The people in America are the kings, not government. And we have to get that into our psyche, into our spirit, so we understand. And this directly lines up with God's word, because God's word, he has granted us power and authority, and we are made in his image. And he is the one that has given us certain inherent and inalienable rights. So when we're saying this, we're using our status as standing as, quote, one of the people. That is identifying, saying it's like a king's decree. And it states here, which is Republican in form. You're going to see that here in a minute, why that's so important. Sui juris is a legal term, and sui juris means that we are standing in our highest possible standing without any legal attachments to us. We're not coming in as some statutory creation of the state. We're coming in as the masters and creator of the state. There's a huge difference there that people get lost on what that really means. So this notice is like a king's decree going out. And a lot of people think that I'm goofy and think that that sounds funny, but that's literally how our system is set up. That was the founding fathers' intentions. And we, because of lack of knowledge, God's word says, my people perish for lack of knowledge. For lack of knowledge, we haven't understood that, and we've let government run over us. But no more can we allow that to happen, and no more will we allow that to happen, especially when it comes to our children. Going down to the next part, please take notice that the people have granted the government certain powers. Not all power. We've granted certain powers, but secured their rights in Article 1, the Bill of Rights of the Illinois Constitution. This Bill of Rights is supreme over legislative powers. That means it supersedes legislative powers. And before we wrote any other part of the Constitution, before they wrote any other legislation into being, they were first created by the people. And you have to follow this flow of the power. The people come together, the people first express their Bill of Rights, then they create government, and then government creates statutes. So we do not give over all power to them. We give certain power to them. This Bill of Rights is supreme over legislative powers, ensuring these rights remain protected and inviolable. All other constitutional provisions and laws must protect these rights. The government created by the people exists to secure, not infringe upon these rights and liberty. And then we're going to tell them, and we're going to show them, see evidence below, Article 1, Section 1 of the Illinois Constitution. All men, and if you want to get into the terminology here, men is equivalent to males and females, or the people. In Illinois, it's expressed in this article as all men. In every other state constitution, a clause of this type starts with the people. But this says all men are by nature, free and independent and have certain inherent and inalienable rights, among which are life, liberty, and the pursuit of happiness. So let's take that sentence right there. All men, or the people, by nature, not by government. Government does not make us free. Us being free to make and control government is what makes us free. God, by nature, has made us free and independent. We're going to get down to these definitions here in a second. You can read, but we're going to put them in, or you can see that they're in there. But that word independent is very important. Independent means that you're separate, not subject to control, restriction, or modification or limitation from a given outside source. That's straight out of Black's Law Dictionary, which even the Supreme Court uses. That word independent is very important. That identifies that the American people are sovereign and the people of Illinois are sovereign and have certain inherent and inalienable rights. Now, they're not uncertain, they're very specific. We have certain, there's certainty there. Not only is there certainty in that we know for sure, but there's certainty and that there's no misunderstanding. We're very certain that we have inherent and inalienable rights, which our legislature is continually ignoring. To secure these rights and the protection of property, governments are instituted among men, deriving their just powers from the consent of the government. So the whole purpose of government and being instituted by the people is to secure rights and protect our property, not to not protect our property or try to trample and run over or interfere with our rights. And that's exactly what they're doing with this bill. They're actually interfering with our rights, not securing them or protecting them. If we go down to the word liberty here, the word liberty is very misunderstood these days. Liberty means freedom, exemption from extraneous control. So if you are independent from government, that means you're not dependent on government. You're extraneous to government. And if you have liberty, you're exempted from their extraneous control. It's the power of acting as one thinks fit without restraint or control and lost by the law of nature. And a lot of people shy away from that, but we can't. Because in the law of nature, you just take something as simple as murder. Thou shalt not murder. That is a common law rule. That is a common law thing. It's not right to go murder. So we don't have we don't have no restraint or control. We don't have a lawless society when we operate by common law and the law of nature. But we have one where there's freedom and liberty to be exempted from outside control, as in the government controlling us. But we are bound by certain laws and rules, like thou shalt not steal and thou shalt not murder. Now we get down to, and that again is straight out of Black's Law Dictionary. Now we get down to the next definition, a constitutional right. Because remember, the entire Article 1 of the Illinois Constitution is outlining our rights or enumerating our rights. A constitutional right, by definition, is a right guaranteed, not questionable, but guaranteed to the citizens by the Constitution, and so guaranteed as to prevent legislative interference therewith. So we could stop this entire thing right now. I don't even have to read the Homeschool Act. As soon as it came out, the people who have learned the fundamental principles of law, did not even have to read it to know that it is excessive jurisdiction or they're exceeding their limitations of power. Didn't even have to read it. Now, I did read it so we could put together this notice for everybody, but you didn't even have to because, and that's what makes it so simple. If you learn the fundamental principles of law and our constitutions and how they work, you don't even have to read most of the garbage legislation that they put out. And this is the point that I'm making where I think a lot of our representatives who are even against it, they're saying things like, I won't vote for that. They shouldn't be saying that. They should be saying, legislature has never even been granted authority to make such legislation. There's no way we could vote for it. And the people that do vote for it are breaching the Constitution and trespassing the Constitution the moment they even bring that bill into existence. They're already exceeding jurisdiction by just bringing it up in the first place. Justice Scalia once said that the creation of legislation should be a long and arduous process. And there's a reason for that, because when they create legislation, the first thing they should do is say, first of all, can we do this? And then the next thing they should do with it is, how do we write this to make sure that none of the people are ever harmed or injured by an agency trying to enforce this? Because if they are, the legislators who brought that bill into being are on the hook for either writing legislation that trespasses the people or allowing legislation that they've written to be trespassed by agencies against the people. So a constitutional right is a right so guaranteed by the Constitution, so guaranteed as to prevent legislative interference therewith. And again, that's straight out of Black's Law Dictionary, 5th edition. There's a maxim of law that says liberty is more favored in all things. Anything. Liberty is more favored than all things. So the first thing that they should be doing when it comes to writing legislation, which is law, is make sure that they're favoring liberty over everything else. Another maxim of law, and this is echoed right in Article 1, Section 23 of the Illinois Constitution. A frequent recurrence to the fundamental principles and firm adherence to justice, virtue, and original law would be common law and our Constitution, are indispensably necessary to preserve the blessings of liberty and good government. It's indispensably necessary. Fundamental principles win the day. Fundamental principles are maxims of law and our constitutions and how they all work together. It is those things that are supreme or above, over and over, any legislation that is written. So whether or not these people who are ignorant of the law, they have attorneys write these bills, attorneys block and hide things in the Constitution. They want to bring everything into statutory land rather than just addressing whether it's constitutional or not. And that's where I get really frustrated, and we get really frustrated because there's been a lot of big names that are saying, well, would I really vote for this bill? No, but does it really attack homeschooling parents? Not really. It doesn't really. Yes, it does. It absolutely does by the mere fact that they can't even write a bill to do this. They literally can't do it because we have a constitutional right which is guaranteed to prevent legislative interference therewith. Please take notice. The people are guaranteed that the state of Illinois is a Republican form of government. Now, here's where we're going to see why it's so important that we understand that we're a republic and not a democracy. Because remember, a democracy, as a true, strict democracy, does not observe people's individual rights. They only observe collective rights of the will of the people, and it's the majority of people that win today. A republic, which America is and Illinois is distinct and different from a democracy. We are a republic And a republic means some very important things. In a republic, we reserve our individual rights before we ever let the majority decide anything. So the people are guaranteed that we're to be Republican form. This next sentence here is actually straight out of the Kentucky Constitution. Arbitrary, absolute and arbitrary power over the lives, liberty, and property of free men exists nowhere in a republic, not even in the largest majority. And that's what makes us distinctly different than a democracy. The people are sovereign and have only granted limited power to their representatives. A lot of people shy away from that word sovereign. We should be embracing that word. This isn't a thing. There is a movement out there called the sovereign citizen movement. That's an oxymoron in and of itself. The fundamental law of our nation completely upholds the idea and the fact that the people are sovereign and that the people are kings and that the people are the ones over their government. The United States Constitution, Article 4, Section 4 says expressly, the United States shall guarantee. Now, the word shall in any constitution is impervious to discretion. They must obey it. So the United States, our federal government, shall guarantee to every state in this union a Republican form of government. So if our state chooses to try to do things to not be in accordance with the Republican form of government, the United States, the federal government, we could notify them so that they can do something about it and they can assist us with that. But the United States shall guarantee to every state in this union a Republican form of government, not a democracy. So just because the Illinois Constitution doesn't say as plainly and clearly as say the Kentucky Constitution that we are a republic, we absolutely, in order to even be in the union, we must be a Republican form of government. Why is this important? Well, let's look at the definition of Republican government straight out of Black's Law Dictionary, 4th edition. It's one in which the powers of sovereignty are vested in the people and are exercised by the people. So don't get afraid of that word sovereignty. That word sovereignty is exactly why we have the ability to assemble, why we have the ability to direct and our representatives. And it says it's exercised by the people either directly, which is what we're doing right now, or through representatives chosen by the people to whom these powers are specially designated. Now, these powers aren't fully designated, they're specially designated because we've given them certain limited powers while we've reserved all power for ourselves. And on top of that, any power that we give them, number one, that means that we have that power in the first place because we've given them some of it. You can't give something which you don't have. And secondly, anything that we give them, we can take back. So we can either exercise our power directly or through representatives. Well, we've only been taught that we can do things through our representatives. We've never been taught that we can do things directly like this. Please take notice, it has been a long-held historical precedent that children are the fundamental liberty interests of their parents and the fundamental rights of the parents to make decisions concerning the care, custody, control of their children is protected by due process. People shall not be deprived of their liberty interests without due process of law. This liberty interest includes the right to direct the upbringing and the education of children under their control. Let me get rid of some of these alerts here. These liberty interests include the right to direct the upbringing and education of children under their control, and is protected not only by the Illinois Constitution, but also the United States Constitution, and cannot be interfered with by any legislation. Now we're going to read, I'm not going to read this whole thing. You can pause and read it if you want to. I will read the highlighted parts. This is an excerpt from Troxel v. Granville, where Sandra Day O'Connor, the justice at the time, wrote the opinion. It's from the year 2000, so it's not even that old. And it says that the 14th Amendment, not speaking of the United States Constitution, provides that no state, Illinois is a state, correct? No state shall deprive any person of life, liberty, or property without due process of law. Now, let's not get mixed up on due process of law. We're going to explain that down a little bit further, but keep that in mind. The clause also includes a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests. The liberty interest at issue in this case, the interest of parents in the care, custody, control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. And it's amazing to me that this Illinois legislature thinks that they can even write something. They're going against the entire history and tradition of this nation to try and write something where they can control how parents educate their children. We held that the liberty protected by the Due Process Clause includes the right of parents to establish a home and bring up children, and to, quote, control the education of their own. 2 years later, in Pierce v. Society of Sisters, we again held that the liberty of parents and guardians includes the right to direct the upbringing and education of children under their control. We explained that the child is not the mere creature of the state. Our children are not statutory creatures that legislation has any authority over. Our children and the education that we choose to give them has nothing to do with government because we are independent from government. Now, yes, there are public schools that we can utilize if we so choose, and that government does have some authority over. We've granted them some authority to create public schools, and they do have a little bit of authority there. But they certainly, so if they want to write the Public School Act that with all these declarations and requirements, they could go for it. But when it comes to people who want to educate their liberty interests, which are their children in their home, they can't even touch it. They can't even write legislation for it. Scrolling down here, again confirm that there is a constitutional dimension to the right of parents to direct the upbringing of their children. It is cardinal with us that the custody, care, and nurture of the child reside first in the parents whose primary function and freedom includes preparations for obligations the state can neither supply nor hinder. The state can neither supply nor hinder. It is a parent's. This is fundamentally in line with God's word when it says, "Fathers, train up your children in the way that they will go." In subsequent cases, we have also recognized the fundamental right of parents to make decisions concerning the care, custody, and control of their children. Hello, Illinois. See Stanley v. Illinois from 1972. It is plain that the interest of the parent in the companionship, care, custody, and management, which would be education, of his or her children come to this court with a momentum for respect lacking when appeal is made to liberties which derive merely from shifting economic conditions. There's even an Illinois case that is cited in the Supreme Court about the liberty interests of parents over their children. The history and culture of Western civilization reflect a strong tradition of parental concern for the nurture and upbringing of their children. This primary role of the parents is the bringing up of their children and is now established beyond debate as an enduring American tradition. We have recognized on numerous occasions that the relationship between a parent and child is constitutionally protected. The fundamental liberty interest of natural parents is the care, custody, and management of their child. Due process includes the right to direct the education and upbringing of one's children. And Granville, in this case, unconstitutionally infringes on that fundamental right. Now, Troxel v. Granville isn't specifically about education, but I think you can see that the court held pretty firmly that the fundamental liberty interest of parents over their children and education is pretty darn clear. Article 1, Section 2 of the Illinois Constitution says no person shall be deprived of life, liberty, or property without due process of law, nor be denied the equal protection of laws. A maxim of law said, well, let's go back to that real quick. We shall not be deprived of life, liberty. Liberty would include the parents over their children's education without due process of law. Due process of law is again very important, and let me get down there quick and we'll come back to this. If you look at due process of law, straight out of Black's Law Dictionary, 4th edition, it says due process of law in each particular case means such an exercise of powers of the government. Now remember, government doesn't have all power. They only have limited power to exercise. So it first takes into account the exercise of that limited power as the settled maxims of law permit and sanction, and under the safeguards for the protection of individual rights as those maxims prescribe. For the class of cases to which the one in question brings. Due process of law refer to certain fundamental rights, which that system of jurisprudence, of which ours is a derivative, has always recognized. The law of the land. The Constitution is the law of the land. And look at here. The law of the land, due course of law, and due process of law are synonymous. They're the same. They're exactly the same. So due process of law means the exercising of powers of government as the settled maxims of law permit. That's why we list our Constitution, because that's the law of the land, and we use the maxims of law because they're settled. They're no longer even something that are in question, although they're questionable now because nobody understands it. But it is settled in law, and judges would have to rule based off of that when you bring the correct argument. And that's why it's so frustrating when you see people out there, and including representatives who mean well, but they're ignorant of what the settled maxims of law and our Constitution actually say and how it all works together. You even see that recently here in Illinois with the FOID card. They tried to make a FOID card so that people in Illinois, if you wanted to have arms in your home, that you have to have some government license to do it. That totally goes against the maxims of law and our fundamental principles in our Constitution. And now we finally got a judge that acknowledged that. And now what's going to happen? Because anybody who was ever charged with that was ruled unconstitutional. It's unconstitutional the moment that they did it. It's just now that people have started to figure it out. So we could actually take this moment to thank our government for becoming so oppressive and so tyrannical that it actually causes some people to go and learn what the Constitution and the maxims of law are and what they mean, so that we know how to be sovereign over our government. Maxim of law. No free man shall be deprived of life, liberty, or property, but by the lawful judgment of his peers, or by the law of the land, that is, by the common law. The common law is common to all men. Common law includes due process. Due process includes the Constitution. The Constitution includes that we have a trial by jury any time before they want to try to take any liberty from us, any of our rights from us. The only way to take the rights away, let's in this case, the only way to take the rights away from parents to educate their children is on an individual cases to charge some parents with some sort of a crime and take them into um, a court of record with a trial by jury with an independent magistrate and charge them with some type of a common law crime. So if there's some evil people that want to abuse their children at home, and there's somebody that has seen this and is willing to fill out an affidavit for it, and they charge them with a crime, then it's possible that they could lose the right to educate their children because they've committed a crime, not just because they've not chosen to go to public school. Miranda v. Arizona, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Please take notice that government cannot bypass constitutional mandates by relabeling or reorganizing. Indirect violations are as unlawful as direct ones. The rights of people over children's education is protected from government overreach. The Illinois Constitution allows regulation of public schools, but does not override the secured rights in Article 1, Section 1. The free people of Illinois cannot be forced into the public realm of education or have their private liberty interests regulated without due process. It just can't be done. It's an impossibility. It is impossible for them to pass this legislation on by law. It's impossible. That doesn't mean that they're not ignorant enough to do it, and they may do it, and then we would have to. But then, if they've done that and we've given them notice, when we give them this notice, they're going to knowingly be trespassing the Constitution. We're going to be taking away from any plausible deniability that they have. Let's see, we went over due process here already. Please take notice that the people have reserved and secured their persons, papers, and property and possessions against unreasonable searches and seizures and invasions of privacy unless due process is followed. An individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. Government cannot relabel the people or their liberty of private education into statutory creations or known as persons, such as calling a parent. Now, this next part comes right out of what they're trying to do. And this is in essence how they try to make statutes or these acts, this legislation, quote unquote constitutional. Because they just relabel things and move things around. So they're like, well, we're not taking the parent's liberty away. We're taking a homeschool administrator's liberty away. Well, they can't do that. And I'll show you here at the end of this why they can't, and even our current Supreme Court agrees. But if you go through and you look at some of the definitions and how they've written this legislation, you can go read that bill yourself. After you read this, you'll understand what it's saying. And they try to call a parent a homeschool administrator, relabel children to homeschooled child, relabel private right of education to homeschool program or lawful school, relabel their private papers to quote educational portfolio, replace due process without a trial by jury in a court of record and judicial tribunals with a quote truancy hearing, and then replace independent magistrates with administrative law judges and or hearing officers. So that's what they do with all these things. If you were to even go to one of these quote unquote courts, they call it a truancy hearing, and then they use an administrative law judge, which has nothing to do with. Now, it might be the same guy in the same black robe, but he's operating under a totally different set of statutes and codes that are for, like, if you were in public school. But you're not. If you're not in the public school, then you're not subject to any of that stuff. And then there's a whole different set of things that just because you're in public school doesn't mean they can even trespass your rights. But that's a whole different ball of wax, and we're just going to keep this focused on to the Homeschool Act for now. Where were we? Or any other statutory definition. So they can't use any of these other, they can't just relabel things and use any other statutory definition to abrogate or derogate these constitutionally secured rights. Nor can government create discriminatory classes of people called homeschooled child. So all of a sudden now they're going to create different classes. And what do we have? A public school child and then a homeschool child? We're going to create division that way in this nation? No, that's not how it works. That's not how a republic works. The people realize that legislature cannot regulate their rights, nor can legislature create legislation to cause administrative agencies such as the State Boards of Education, DCFS, and the Illinois State Police, among others, to do something legislature cannot do themselves. These agencies have been using false and unlawful authority with attorneys who have not understood the law to take the liberty, property, and rights from the people without constitutionally required elements of due process, with courts of record and trial by jury. This has been openly spoken about by the U.S. Supreme Court in recent SEC v. Jakarski case from and then you can look up this docket number here if you want, but that's where Justice Gorsuch specifically called them out during oral arguments because in that particular case, the SEC, which is an agency, was trying to relabel and rename things, and he called them out exactly for that. And I didn't make up this sentence up here where it talks about relabeling. That's a direct quote from the Supreme Court. So you don't have to take my word for it. We're just letting the Supreme Court speak, and they are upholding. They have turned a page in the Supreme Court. They're going back to text, history, and tradition. They're going back to the fundamental law. They're going back to using our constitutions because the people have had enough of this overreach and excessive jurisdiction of government. In Article 1, Section 6 of the Illinois Constitution, it says, the people, now remember that word's important, shall have the right to be secure in their persons, houses, papers, and other possessions against unreasonable searches, seizures, and invasions of privacy. It is your privacy if you want to educate your child at home. That's your liberty interest. You don't have to make a public declaration that you're going to homeschool. That would be an unlawful. They have to issue a warrant with probable cause supported by affidavit to even be able to begin the process to try to get you to do something like that. They can't do it. They just can't do it. Maxim of law. The language of a statute is to be understood and interpreted like ordinary spoken language. Now, this gets tricky because that's how it's supposed to be, but that's not how they do that. But they know that the people just regularly read that. So the layman or the common man goes and reads the Homeschool Act, and he doesn't read it like an attorney would with these terms and definitions and everything. He reads it and he says, "Oh my gosh, I'm a parent. I homeschool. They're telling me I have to do this." Well, no, it doesn't say that you have to do that. You can literally ignore that entire legislation. Now, I'm not saying that they should pass it just because of that, but if the people understood what it says and what it doesn't say because of all these statutory definitions, then we would know that it doesn't pay any attention to it. But what they did is they switched out words and relabeled our children to homeschool child and parents to homeschool administrator. And then they try to get us confused that way. To derogate from law is to take away part of it. To abrogate law is to abolish it entirely. And that's exactly what they're doing. They're derogating and abrogating our Constitution. A home is a social unit formed by a family living together in one dwelling. It's not a, quote, homeschool with a homeschool administrator. The Illinois Constitution expressly says the right of trial by jury as heretofore enjoyed shall remain inviolate. We always have had the right of trial by jury. We always will have the trial by jury, not a truancy hearing. Don't ever let them take you to a truancy hearing. Don't ever let them try to pull one over and act as if the people don't have these rights anymore. because maxim of law says it would be idle and trite to say that no right is absolute. Another maxim of law says he who does a thing by another is considered as doing it himself. The acts of an agent are the acts of the principal. And we put that in there specifically because how do they enforce it? First, legislature writes this evil, wicked law that tries to trespass on the people's rights. And then they try to empower the State Board of Education, the Illinois State Police, and DCFS, which are all statutorily created agencies. Even the Illinois State Police is an agency under the executive control under JB Pritzker, and they empower them to do things. And then they say, well, we didn't do that. DCFS did it. The representatives didn't do that. No, they did because they wrote legislation. They wrote legislation that wasn't clear on how to follow. The PICA Act concerning the quote unquote assault rifle ban is a perfect example of that. They wrote some garbage legislation, threw it out there, and then they let the Illinois State Police make all the rules on all this thing and determine what things mean. Which that's exactly what the whole Chevron doctrine case is about. That the Supreme Court just put a tombstone on with what case was that now? Raimondo. And yeah, it's the whole thing's garbage. We've been operating so far outside of our constitutions for so long that now it's come to this where they try to tell us how to educate our children at home. Maxim of law. Power can never be delegated, which the authority said to delegate never possessed itself. So, power can never be delegated. Now remember, the people have all power. The people have delegated certain power to legislators. Power can never be delegated, which the authority said to delegate never possessed itself. Did we delegate power to them to do any of these things? To write legislation over our private liberty interests? No, we did not. So how could they delegate any authority to DCFS, to the Illinois State Police, or to the State Board of Education that they don't have? Those guys have power delegated to some public realms, but not private. And your home is the private realm, not public. Please take notice that any statutory acts created by legislature must be in pursuance of the Constitution and the common law to be the rule of decision. The legislature has not been granted any power to use statutory language to circumvent these rights and have been reserved by the people and secured within the Constitution. And a maxim of law says an affirmative statute does not take from the common law. So again, even if they affirm this garbage statute that they've written, which is totally unlawful, it does not take from the common law. What is the common law? Part of the common law is your rights expressed in the Constitution. So an affirmative statute of them making a quote truancy hearing does not take from the common law right of having a trial by jury. Understand that. That doesn't mean that they can just do this and start doing things, but this is so clear and plainly obvious on how we should be pushing back. We shouldn't just call our representatives and complain. We need to deliver them the truth, deliver them the law, and then if they choose to trespass and violate, you're going to see later on in this that they don't have the immunity that they do have. Our representatives do have immunity from lawsuits and things like that as long as they're following the Constitution. They're protected. We want we're the people are good masters and want their servants protected so that they can do what they need to do with law in the areas that we've given them the authority to do it. However, if they step outside of that, they're no longer protected by the Constitution. Please take notice that in a Republican form of government, the people have not given up their original and highest status as the creators and masters of government and have reserved the right to correct errors by government. The people are private, separate, and distinct from government. Government has only been granted limited jurisdiction over public matters. Additionally, the people have retained other rights which are not enumerated in the Constitution. The education of people's children, their liberty interests, are private, not public. Article 1, Section 24 says the enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the individual citizens of the state. So just because we didn't express the right of private education or privately educating children in our home doesn't mean that we don't have it. Because we have way more rights than we even know about. And all you have to do is begin to read other state constitutions that if the people there are identifying certain rights that they have that Illinois doesn't, then you can look to that and say, well, we have that same right because all the people of all states are equal. Article 1, Section 12 says, every person shall find a certain remedy in the laws for all injuries and wrongs which he receives to his person, privacy, property, or reputation. He shall obtain justice by law freely, completely, and promptly. We have the right to privacy. One of those rights with that privacy is the papers in our home, which would include your quote, what they try to call educational portfolio. Maxim of law says the people is the greatest master of error. Now, there's a reason that it says that. It's because, again, the people are the creators and the source of all power for the government. The people created it. When government messes things up, like they have in this case, we can't have them fix it because they're the ones that created the problem in the first place. So we have to step in as the people and be the masters of the error. That doesn't mean that we created the error. That means that we have to fix it. And so we have, if you read Article 1, Section 23 of the Illinois Constitution, it says that the people, that's the only duty and obligation that we have, if we so choose in this nation, is to recur to the fundamental principles of law. And when we recur to these fundamental principles, that's recurring to our Constitution and recurring to these maxims so that we can get these things fixed. Maxim of law. The welfare of the people is the supreme law. Now remember, the supreme law of the land is the constitutions, and the welfare of the people, the entire purpose of government is for the welfare of the people, namely to protect our rights and our property. Maxim of law. No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear or unquestionable authority of law. So the right to privately educate our children, we are free from any restraint or interference from government, unless by clear or unquestionable authority of law. I think I've proven in here that they clearly don't have unquestionable authority of law to do this. Here's a goodie for one for the sponsors to read and the people who may vote in favor of this to read. The deprivation of any rights may be punished. Next maxim. Every man's house is his castle. Even though the winds of heaven may blow through it, government officials cannot enter it. And that's why we are protected by due process, which includes the only way that they can come and do something in your home is with a warrant supported by an affidavit, particularly of certain things that they are to search and seize. And then you're afforded a trial by jury, following the course of common law with an independent magistrate, not going to all these hearing officers and stuff. That's why the whole DCFS program is a joke. And they've been stealing people's children using not law. A man's house, or a man's dwelling house in his castle and fortress, not merely for his own personal protection, but also for the protection of his family and his property therein. Please take notice, the people have reserved full liberty interest in their children. The state has no equitable interest or granted authority in the quote, best interest of the child without due process. The government must protect these rights and liberty as mandated by the Constitution. One of the innovations of law that they've had is this quote best interest of the child, as if the state can determine what the best interest of the child is. No, state, we did not give you that authority to decide what's in the best interest of the people's children. That's for each individual parent to decide. Now, if there is things like abuse and neglect going on, then they have to follow the course of due process, not their statutory procedures, to remedy that problem. So the common law of the land protects children. We do not need all of these statutes to protect children. The common law does it. The Constitution does it. Government cannot engage in the practice of preemptively preventing perceived opportunities for harm by attempting to force private people to declare intention to educate their liberty interests privately. This defies the presumption of innocence. This clause was put in this notice because that's one of the arguments that they're trying to make. Well, some parents might use homeschooling to abuse their children. Yeah, that's a reality of that. But remember, in a republic, the opinion of the majority doesn't overrule the individual and private rights of the people. And unfortunately, that may be true, and there may have been some children that have been harmed in that manner, but there's also all different types of ways that children could be harmed. Um, this bill accomplishes nothing towards that end, and even if it did, it still wouldn't be a good enough reason to do it because they haven't been granted the authority to do it. Um, that stuff has to be dealt with criminal things, with criminal courts, and with things like affidavits and trial by juries and things like that. Um, so what they're trying to do is they're trying to use the quote best interest of the child and preemptively preventing perceived opportunities for harm. So like maybe somebody could keep their children at home to abuse them instead of sending them to the public school so they won't get found out. Yeah, but then you're defying the presumption of innocence. Like the people are presumed innocent until proven guilty. So you can't do that. The same thing goes with why the Floyd card's going to fall here. It's starting to fall, and it's going to continue to fall because you can't make people jump through statutory hoops um, when it defies the Constitution. Almost done here, folks. Please take notice that the people have noticed the statutory scheme of legislature, House Bill 2827, and the practice of government relabeling, redefining their rights to gain jurisdiction. That's the whole reason they do this is they know they can't do it over the people. They can't do these things according to the Constitution. So then what they do is they use different terms to then try and slide you into a place where they may have jurisdiction. So they may have some jurisdiction at public school. So they may want to get to treat you like they do in public school. And they have some jurisdiction there. They have some granted authority. So what they try to do is turn your private home into a public school. That's literally what they're trying to do on paper. And we know what they're doing. We're well aware of it. But I'm still very frustrated. We are still very frustrated with many of our state reps and other people that are very vocal about this not using the actual law. Instead, it's just like try and shout and scream. I'm as mad as anybody about this. However, we have to, in peace, deal with these things according to law, because anybody who is a conservative or biblically minded, if you're homeschool minded, you need to know the fundamental principles of law. If you're patriotic minded, you need to know the fundamental principles of law, because all of these things that have been done in this state are because we're not following our Constitution. And it looks like just recently here that Mr. Madigan found out that there's actually repercussions for this, whether it's now or later, Justice is coming. Justice will always be served. The people demand recognition that government has no authority over private education, which is distinguished from the statutorily created term non-public, and insist on immediate cessation or modification of related legislation to acknowledge this right to ensure police power and agencies do not exceed their jurisdiction. I've explained that already. This is just restating it once again. There's one more thing I should explain. This term non-public that they're using. And what we have to understand is that first of all, there's public schools. Like your local school district is a public school. It's statutorily created. There is some jurisdiction that the state has there. Now they can't ever go against your rights, and there's all kinds of stuff there that they do. But the point is that they can do it. So we're going to leave that topic alone for right now. The next part is what we call private schools. Now, your local private school, your local private Christian school or whatever, if they are statutorily created, which almost all of them are, that means they're either a non-for-profit or they're um, a entity under the state. If they've created themselves by the state, that they are subject to some statutes. They are subject to some of the policies and procedures. And we tend to call them private schools, but they're really not. They're correctly called non-public schools, but they're not private. You got to understand the nuance there of this distinction between public and private, because government does have some authority granted to the public realm. The private realm, they do not. So a private Christian school, as we would call it, if it is created under the state of Illinois, then it is going to be subject to some legislation. However, your private education of your liberty interest in your home is technically what private school is what private education is. You're not utilizing the public realm to do that. I hope that made sense. A remedy may be had by publicly stating that the government has no authority over the people's liberty interest, which includes the private education of their children. I hope there are some state reps that listen and read this and start to speak this way. I hope that they will start to recur to the fundamental principles. I hope that they will stop with the grandstanding is fine, but you got to grandstand using the correct terminology and the correct words so that we get this stuff addressed to the core. We do not have to even, we shouldn't even be worried whether or not they can quote unquote have enough votes to pass this thing. Even if they pass it, it's null and void on its face because they were never granted authority to do it. Now, that doesn't mean that they're not going to use the state to attack people, because we've seen that they do that. However, at the end of the day, the law of the land prevails when people make the right argument. And you just saw that. How long has the FOID card existed? And now it just took until what, a day or 2 days ago that they finally, a judge finally got it right, at least in part, because there is no regulation that they can do within your home. Within your private home, there's no regulation. They can't do it with guns. They can't do it with your education of your children. It's that simple. Any attempts to rename or renumber bills with the same subject matter may be viewed as tortious interference of your contract with the people. In case anybody wants to argue about it, there's plenty of ways to show that the Constitution is a contract. They are trustees and servants. Our representatives are trustees and servants of the people. The people are the beneficiaries. It's public trust. It's cut and dry. We've been moved so far away from that. And when they're trespassing our rights doing this, they're breaching the trust, which then leads them to unofficial acts. Because if legislation leads agencies to exceeding their jurisdiction, legislators voting for it may lose immunity for these unofficial acts, see Trump v. US, that are beyond the limits and constraints of the Constitution. When any of our trustees or servants, any of our elected officials, any of these public agencies, when they go beyond the limits of the Constitution, they're breaching the trust and they can be held responsible in a personal capacity for that. They they have been led to believe that they have immunity just because they hold office or because they're government. They've been led to believe that um, it's unqualified. They just have immunity just because they're in office. That's not true. That is not true. What is true is that they're trustees and servants of the people, and they need to abide strictly by the terms of the contract in the Constitution. And if they don't, they're in breach of contract, and they can be held very, very accountable. If you believe any of the above claims are untrue or that you have authority to harm, infringe, or trespass upon the rights of the free people, please provide clear and unquestionable constitutional provisions that grant you such authority to create legislation that would give authority to agency workers, police, corporations, judges, or any other public officer to make rules for the people and their families, then enforce without constitutional due process. Because that's exactly what they're trying to do. And if they can't show us where we've granted them authority, then they're outside the bounds. They're outside the bounds of the Constitution. All responses must be in writing by affidavit, sworn under penalty of perjury, and postmarked within 5 days receipt of this notice, or you agree by acquiescence all statements in this notice to be true in fact. I think that you can see from providing all the evidence within the notice that they are true and factual. If they don't respond to this with an affidavit, point by point, going down and explaining where they have authority to do it, then they need to respond with an affidavit. If they don't, then they do what's called acquiesce. Acquiesce is actually what the people have been doing all this time. All this time where we've been letting government run over us, we've been acquiescing. That means your silence is acceptance. It means that by being silent, that means you agree. You don't stand up. You don't stand up. Well, it's time for the people to stand up. The whole purpose of the armor of God is to stand in the evil day. That's the whole purpose of the armor of God. So it has now become an evil day in America when Illinois state legislature wants to try to rule over someone's um, private liberty interest of educating their children. And if they choose not to use a public school, that's an evil day. Folks, it's time to stand. But we can't just stand by getting pitchforks and torches and assembling and protesting. We stand by assembling in peace with the law, using the proper forms and communication, and treat government the way they've been treating us. When they want to make a law, what do? They write something out, they post it out there. I mean, every year, January 1st, there's all kinds of new laws that we're supposedly have to follow. We don't even know what they are. But I guarantee you they'll try and charge you with one of them because you've acquiesced. Well, we're not acquiescing to this one. We are not acquiescing. We are going straight on, straight to government with a notice. And if they continue to push this legislation forward and they pass it, you hang on to this because if they try to ever do anything, you can enter this right into the record with that they've received this notice and that they pushed forward, they never responded, and that all the statements in this are true in fact. Any disputes by any public officials who are bound by contract to the Illinois Constitution agrees to have these matters heard before an arbitrator of my choice and bound thereby. Further, you agree you are acting with full knowledge, intent, and malice by trespassing against the people's inherent rights, and no court shall be able to rehear this matter. It shall stand as truth and evidence in all courts of record. Non-perjury responses are invalid. This little clause here at the bottom is just for if anybody thinks that they're going to like maybe one of the secretaries or agents or directors for a district or something of a rep wants to not let their rep see this. Any man or woman who suppresses this notice will be viewed as committing tortious interference with the contract between the people and the reps and agrees to pay $5,000 per infraction. This notice is sent to you in the peace and love of Christ that you may provide due care for those who have all political power, the people. And then all you have to do is fill out your name, sign it right here, put your email in. We're not harvesting your email for anything in particular or trying to make any money. That is so you will get, after you get this signed and you hit submit, it will automatically be emailed to all of the state reps that we have their email addresses for. It will, again, if you want to participate further, you can either mail it yourself by certified mail and you keep that green card receipt, and that's going to be your receipt that you sent this to them. And so if they try to pass this and they try to do any harm against you, then you have the notice that you gave them in the first place. If you want to participate in the group mailing effort, then you can do that. You'll get a follow-up email after this one that has your signed document, and it also has a way to participate in the cost sharing of that group mailing. So either one you want to do is fine. This is perfectly free. If you just want to do that and sign it, go for it. I would ask that you would circulate this video and link around for the jot form because the people really need to begin to learn these things. And this might be the very thing that pushes the people over the edge because if there's anything that these folks don't want, it's a bunch of people who have homeschooled their children who understand the law and know how to use it against them. Um, and I know the homeschool moms out there, they're very feisty individuals. They will, mama bear protect their children, and they will do what it takes. And we don't have to get violent. We don't have to get crazy. All we have to do is use the law in its truth, the fundamental principles, the maxims, send them notice. And if they want to proceed beyond this with this bill, justice will prevail. Justice will prevail. Because if anybody gets harmed by that, we could take all of these notices and we could insert them in and give them to any agency, any judge, anybody that wants to and say, no, you guys already agreed you couldn't do this before you even signed the bill, you agreed you couldn't. Because unless they respond point by point with an affidavit to show where this is wrong, then they agree that it's right. There you have it.